The main advice is, Boy Scouts motto, be prepared. Your best defense is having good paperwork, having done the right thing in the first place, and being able to prove it. Um, that's going to solve a lot of your problems. If you do the right thing and follow the law, then you should be a lot less worried about getting in trouble. Doesn't mean it'll never happen, but you improve your odds. There are certain points of emphasis that the U.S. DOL has been sort of instructing its investigators to really drill down on lately. Employee misclassification was something we talked about earlier between whether an independent contractor or an employee. That's a big issue. Tracking overtime for ag, for the most part, you're going to be exempt, but not always. There's some scenarios where if you're packing for other people, you're going to lose that overtime exemption. So these are areas to be very careful when you're skating close to that line. Payment for all hours worked. This is something that makes sense, but if they've done the work to kind of make sure that they're covered, it's not always just as simple as that. I mean, that doesn't necessarily mean, that, the one for one, for everything that's paid. I mean, if they're paid more than the minimum wage, that's something that the Fair Labor Standard Act is not necessarily enforcing your H-2A wage rate, but it's enforcing the federal minimum wage. Making sure that the work is consistent with your H-2A job order. If you're using H-2A workers, that something we talked about this morning, that making sure that they're not doing work for another grower, or that they're not doing work on a different crop than what was listed, or that they're not, they don't have any duties that kind of fall outside that line. And record retention is a big deal. If they come through and go back and you don't have records for something, the presumption is that you have done something wrong. I mean, it's a violation on its own to not have the records, but the presumption is that you were doing something wrong and that you've destroyed those records on purpose. It could be, we keep them in the barn, we had a wet winter, they just sort of went away. But, you need to be very careful with this. Part of the good defense, just like with healthcare, if you go into your doctor and get checked up, ideally you're going to have them say, you're perfectly healthy, see you next year, you're doing great. Doing self-audits, having an outside party. If you have an outside attorney come in, then anything that they find is protected by attorney-client privilege, which is helpful, because if you do your own audit and put a memo in there, we screwed this up, we've been underpaying people for years, and that goes in the file, they're going to find that. So, whereas if you have an attorney that says that, they get to say, oh, not so fast, we're just going to put that away. And but kind of go through and make sure that you're finding things before they find something. Have a practice that if you have, so close, a policy that if you have workers that are concerned that they're not being paid correctly, that, well, why was this deduction taken? Or, I think that you missed a couple hours for me, something like that. If they tell you before DOL tells you, you're in much better shape. You can get it right, get it corrected, and, at the very least, avoid having to pay the back wages. Having a good policy that some of you may have heard at past things that Maureen Torrey will talk about, having an employer toolbox, having practices in place and checklists and ways to kind of stay on top of things so that you don't have to worry about it when it comes up. You have a practice in place that if something's gone wrong, you can say, nope, we always do it this way, so that's how we know. Have a point of contact so that if you are audited, there's somebody available that will say, I will be the person that talks to the government investigator, so you don't have, oh, it's Joe from the loading dock. Thanks. Like, oh, sometimes I think we're paid right. I don't know. No. You want to have the person from the office that's on top of it and ready to go. Know who your opening and closing conference participants are going to be. Same idea. That when it comes time to meet with the investigators, you know who that team is and you're ready to go. Be prepared for it. Who's going to escort them on the premises, just sort of making sure that you have practices in place that you're creating the documents you need to and retaining the documents you need to for as long as you're supposed to. These are some of the things that you should expect that they're going to look back to. They can look back for 3 years. They're going to want payroll records at a minimum. Wage and hour, that's what they do, wages and hours, boom. They can also go beyond that, though, if you have written employment practices, procedures, your policies for keeping time. Do you have a time card system, or do you have somebody, a supervisor, that's just writing it down in pencil? Kind of how do you track these things? gross revenue for the previous years, that's not theoretically the wages that you're paying, but that tells whether you're going to be covered by the Fair Labor Standards Act. If you have sales above a certain number, that's what triggers your coverage. If you're a very small business, theoretically, FLSA doesn't apply to you. A new thing that the federal government's been pushing is customer lists. And they say that's included in kind of a general list. They say we want the following documents. There's 37 kinds of documents. Customer lists. Well, that doesn't really have anything to do with what you're paying your workers, kind of who you sell your apples to. You know, they'll say, well, it has to do with whether you're covered, and so, you know, there's ways around that, though. You can stipulate, look, we're covered. You know, we had $200,000 in sales, $2 million in sales last year. We'll agree that we're covered. Don't worry about it. The concern is that it's less on the East Coast and the West Coast. They've been pushing hot goods issue, that if they find a violation, they're going to come in and say, all of these crops are seized. You know, you can't sell them. We're putting a hot goods order on it. For something like apples, where it can theoretically store for a few weeks, that's okay while you get that sorted out. If you're picking strawberries or blueberries, you know that by day 5, they're garbage. So, you know, by the time you fight it out, you know, they had this issue in Oregon where they slapped a hot goods order on it. They said, you can fight us, but you can take it to court and expect a decision in about 10 weeks. And they're like, we will be out of business by then. So it's a provision in the Fair Labor Standards Act that says that any goods that were manufactured in violation of the act are not to be sold. So when they put the order on it, basically, if they know your customers, you know, say that you grow, you know, raspberries and you sell them to Wegmans, then they get a report from one of your workers. I don't think they're paying me correctly. Before they've found any violation, before they've even passed go, they come in and say, we've had a complaint about you. We're putting a stop order, you know, hot goods order on those raspberries. And then the next call, once they have your customer list, is they go to Wegmans and say, oh, by the way, you have, or if it's a packing company, you know, some of the raspberries that you've received are illegal raspberries, and if you pass them on, you're now in trouble. Well, now you're a pariah, you know, that basically you can't sell, you're going to be poisoned and it can take weeks and weeks to sort it out. So, you know, be careful. Maybe there's a way to work around kind of giving up your customer list is sort of the takeaway on this. Yeah. That's right. That's right. They'll lift the order if you prove that you're innocent, but by then, that's the federal, yeah. Not our friends in Albany. You know, they're perfectly lovely. They would never do something like this. It's those monsters down in Washington. So after initial contact, you know, a lot of times you'll get it as a letter. You could be as a phone call. Sometimes, and again, this is more, you hear more about it in the West than here. They will tear up, you know, pull in Starsky and Hutch style, you know, fishtail in, jump out, guns drawn, you know, give us your documents. And here, hopefully, they'll be more civilized as we are on the East Coast, and they would do it perhaps as a letter or a polite invitation or a phone call. Have your documents ready. Hopefully, you've already gone through an internal audit. You know what you have. If there's anything missing, you've corrected that. So you have the documents ready to go. You have your point person who's going to talk to them when they show up. If for some reason, you know, there's a fire, you lost some of the records, you can explain what happened there. Just sort of be ready for it. You know, they'll give you a head start. Usually they'll tell you, you know, we're going to meet with you in a couple days. Gives you a couple days to kind of get ready, get in order. Again, this is all just sort of going through it. If what they're asking for is going to, you know, be so disruptive, you know, they're coming at harvest time. You don't have office staff. You're, you know, mom and pop, you know, you're a smaller grower. You don't have this. You can tell them, look, now is not a great time, but we could talk to you in a week or two, something like that. They'll tell you, no, we want to talk to you on Thursday. There's room. You know, generally they'll be reasonable and you can push back. It could be for some of the records that you don't feel like they have a right to it, you know, some of the customer lists, things like that. It's possible that you can say, get a subpoena for that, and that will slow things down for a couple days too. But, you know, generally, you know, you're going to give them the records, you know, be reasonable. It can't be, talk to me in 2018, but, you know, a few days, you know, they'll usually play ball. When they show up, make sure that they actually are an investigator. You'd be surprised. These things happen. They'll explain to you what they're looking for. And sometimes they'll just say, I'm from the U.S. Department of Labor. Well, the Department of Labor does a lot of things. They could be an OSHA investigator looking at safety issues. They could be coming from Employment and Training Administration, ETA. they're looking to make sure that you're complying with your H-2A applications, doing everything correctly there. They could be from wage and hour that are looking for payroll. There's a little bit of overlap there. Like wage and hour will look at what you're paying and kind of how you're using your H-2A workers, but they can't look at safety issues, and vice versa. OSHA doesn't really care what you pay your guys, so just kind of know who you're talking to and what the issues are going to be. Have a team that is available so that it shows you're taking it seriously. You have people there that can answer questions. You have a point person and somebody from senior management that can actually talk to them and be ready to go. You don't always need a lawyer there. Depends. Sometimes that can have a chilling effect. Sometimes it could be helpful. It's a tough call. Something that you can ask them, they won't always answer, but you can ask kind of, is this just a random audit? They kind of go through everybody, and if you're in the H-2A program, if you haven't been audited yet, you're probably about to be. Or is it based on a complaint? You had a worker that thought, you had short paid them or treated them incorrectly. They won't necessarily tell you who it was, but at least oh, okay, that's right. The guy that we fired 9 months ago, it could be from that. So generally kind of what to expect, developing information. What topics are they looking at? The Migrant and Seasonal Worker Protection Issues, MISPA, Fair Labor Standards Act, that's dealing with overtime and minimum wage issues, or H-2A, that did you pay them their inbound travel in time? Did you pay them the correct amount of food for while they were traveling? Is the housing in order? Are they working outside the job order? All the issues that arise out of the H-2A program. How long they think it's going to go, and if there's some group of employees other than your whole workforce that they're really looking at. You can talk about having a protocol for investigations. That's something we talked about this morning. If there's a food safety issue, if you're during harvest, there's certain times, certain places that are not good to be talking to people. If you talk to them up front, it doesn't look like you're hiding something later where you say, don't worry about these guys over here. You're saying, no, we can talk about it. We can work out a schedule. You can talk to them after work, as they're clocking out. You can talk to them here. We'll make a conference room available. We're willing to cooperate, but it can't just be, walking through the field, stepping on crops, kind of interrupting things every day. If you can have a meeting with them at the end of every day, just make it a conversation so that you know what's going on. Where's this headed? Have you found anything? Okay, we're in good shape. We're trying to do the right thing, but we just want to make sure. The idea is to kind of correct things as quickly as possible and kind of stay on top of it. There's ways to avoid penalties even as you're going through the process. If you're giving up documents and, a lot of trade records, you don't necessarily, once it becomes a public record, you lose control over it. Department, probably won't be giving it out, but if it becomes part of something that could be Freedom of Information Act requested, you want to be careful of that. So if it's something that is a legitimate trade secret, mark it on there. That's your last chance. Once it goes to them and it's not stamped that way and they get a Freedom of Information Act request, it's going to go out to the public, to whoever asked for it. You don't have to create new documents. You do have record-keeping requirements under the law. Under state and federal law, you have records that you're required to keep for a certain amount of time. You don't necessarily have to make up a new spreadsheet. They have very smart people and good computers. They can do that too. If they haven't asked you for something, you don't have to give that up. They know what they're looking for. Be careful about that. But, people generally get into trouble by answering more questions than we're asked. DOL has the right to kind of come in, just watch what's going on, see how you're using your workers. If you have people that were brought in to pick apples and they see them picking cabbages, that's something that they're going to keep an eye on and keep track of. At the same time, we've seen people that had been using workers incorrectly, and then for that day they told everybody to show up sick or kind of changed it to try to cover it up. That doesn't go well either. Be careful, but don't be smarter than, people try to be smarter than they are and try to, avoid some of these issues. Have good practices in place in the first time. That's not the time to suddenly, get right with the law and kind of come into compliance. They'll figure that out. They are going to figure this out. You should have been doing the thing the right way the whole time. If you have a workforce of H-2As that aren't necessarily proficient in English, the investigator may or may not speak Spanish. Even if they do, you would probably want to know kind of what that conversation is, but just on the possibility, if you have a supervisor that can translate between them, that could be helpful, sort of making these guys available. Again, the individual employees are not required. It seems like it, and a lot of the guys, probably again less on the East Coast, but they will show up strapped, carrying big gun, badge out, they're ready to go, like they're ATF or something. They don't have to talk to them. There's no requirement. It's not, it's even with the police, you don't necessarily have to talk to them. People assume they do because they're very authoritative and make it seem like that. If they don't want to talk to them, they don't have to. Make it clear that they are not to be bullied. Go through the documents with the employees. They may try to get the employees to sign statements, and that's going to be an exhibit that is used against you later. If you have a former employee, somebody that was fired, and they're the one that introduced the complaint, a lot of times you will have a heck of a time trying to find out who it is. They're going to treat them as a confidential informant, that they're basically kind of a mob informant, and they'll protect their identity, and so they'll never tell you who told you this. So it makes it harder to defend because you don't know who said that or kind of what their background is, but a lot of times they'll protect that. Sometimes if you push it and go to a hearing, eventually they will tell you, but even then they'll redact a lot of the information, and it's extremely difficult to figure it out. Once they've gone through this, and this could be something that takes a day, it could be something that they just look at your records and you never really have much face-to-face contact with the people, they'll have a closing conference. They'll get back to you and say, we've gone through your records, and then the closing conference could be a couple days later or a couple months later, and they'll tell you, this is what we found, these are some of the violations that we think that are going on here. We've gotten this approved by our management, and then again, you want to kind of show up, be respectful, have people that can speak to that. That's not the time to argue with them. If they found it and they put it down in writing, gotten approved by their manager, you're not going to convince them otherwise right there. Be ready, kind of be respectful, listen to what they're saying, and that sort of starts the process to negotiate with them. Generally speaking, they're just trying to get you to be complying with the law. If they found bigger violations, there's something where it's going to go forward. But there's some things that you can talk about and kind of correct it. If it's a housing issue, it's something that you can fix. It's not necessarily missing pay or missing wages. Generally speaking, they won't always tell you up front if they're going to look for civil money penalties. They will tell you, this is the amount of back wages that's missing. Please sign here agreeing that you owe us money. If then people sign that, and then it comes back a few weeks later, oh, by the way, I think we forgot to tell you, you owe us twice that in civil money penalties, and you've already agreed that you're guilty because you signed the document back then a few weeks ago. So, be careful. Make sure that you're figuring out the whole amount that's on the table. It might not just be back wages just because that's what's on the first document. Talk about ways, if there's a compliance issue that you can fix going forward, just sort of start the conversation with them. Be careful about what you agree to because of that. You don't necessarily know what it is. And a lot of times, if it's a small amount, that's fine. And then they come back 2 years later, now you're a repeat offender when they find the same violation. And so now it's going up and up and up. If it is a small amount and you feel like you did it, that's fine. I mean, there's parts of it where you will agree with them. That's okay. If you really do disagree, there's room to push back on it. Don't necessarily pay right away. Don't promise. Be careful. Be very guarded about what you say. There's plenty of time to pay them later. They'll pressure you to sign it on the spot. Tell them, we want to take a look at this. We'll get back to you in a week. You can pay it, you can negotiate it, or you can fight it. There's room, there's an administrative law judge procedure in the federal government. If you disagree, where you can challenge it and a judge will consider it. And it depends a lot on the amount. The legal fees at some point, if they're looking for $400, it's really not going to make it worth your while to, it may be worth a phone call to them. You may want to ask and kind of make sure that they're on the right track, but you're not going to go hire a big law firm and pay $50,000 to save $400. That's just not good business. Although if you have to, sometimes if they ask for enough money, you do have to call in the cavalry. Be prepared to fight, if you have to. Think, we're okay with it this time, but is this going to lead to future findings that's going to hurt us? If they're alleging something like willful misrepresentation, that could get you kicked out of the H-2A program. That's not something that, you should take lightly. If you can put in a language in there that says, we're settling this because we don't want to fight you, but we're not necessarily agreeing that you're right, that's best for you, because then when it comes back around a couple years from now, you know, you have something to stand on. They've told us that they don't respect those. They don't believe that that's valid, that it's just words that they put in there because it makes the employers feel better, but it gives you a starting point to kind of make the argument. And just the main thing is just be careful. You know, get it right the first time. You know, have more documents than you think are necessary. You know, stay on top of it. Obviously, complying with the law is the easiest way to avoid fines in general, but there are a lot of little things along the way that can trip you up.